Ready to swap screens?
Yeah. I did.
All right. Mm,
Oh wait, no, you had the right. It was correct the other way.
Oh, okay. Now?
Yeah, it's good.
Okay. All right. Oh, think we got everybody. All right. Good afternoon, everyone, and thank you all for joining us for today's of month of service presentation of Wills and Advanced Legal Planning, Part 2, How to Draft Your Own Will and Todd. My name is Nia Murray. I work as the Programs Coordinator with Neighborhood Recovery Community Development Corporation, and we are one of the partners in the A Month of Service collaboration. Also included, we have Lone Star Legal Aid. And on behalf of Lone Star Legal Aid, we have Ms. Jessie Campbell, who will be providing the presenting and providing the information for you all today about wills and advanced legal planning and preparing your own will and Todd. But also included in our partnership is the City of Houston's Department of Neighborhoods, the Earl Carl Institute, Texas Legal Services Center, the Harris County Attorney's Office, Houston Volunteer Lawyers, the Harris Central Appraisal District, and the Harris County Tax Assessor and Collector's Office. And together we make up a month of service. And basically, a month of service is the collaboration of all of our organizations coming together on a monthly basis and offering a variety of different workshops, resources, and information to the communities that we all serve relative to asset protection, asset building, community empowerment, and the maintaining of generational wealth. We know that there are several communities and people that are out in various communities that don't have access to available resources or don't know where to go for available resources. And so we want to do our best to help contribute and bridge that informational divide and provide as many resources and information to the community as we possibly can that could help assist with any of their civil legal concerns, anything that can help them with saving money, as well as protecting their generational wealth. We decided to collaborate several years ago, even well before COVID, in an effort to create a larger impact and do our part to get as much information out to the community. So we were pulling together a lot of our initiatives and created this collaboration. So we used to do these presentations all in person, but of course, due to the pandemic, we did have to switch to the virtual platform. But it has allowed us the opportunity to reach people not only from this across the city of Houston, but Harris County, surrounding counties, and even across the entire state of Texas. So, regardless of where you are joining us from today, and viewing this presentation or watching it later on, do know that the information is relative to laws in the entire state of Texas, that it's not just for the city of Houston or for Harris County. So do keep that in mind. This is your opportunity to ask questions of the legal professional that is on that's providing the information for you all today. But do know that we are on a public platform, that we do record the sessions, that we do um, uh, broadcast live on social media. So we do try to ask that you keep your questions to be as general as you possibly can and not divulge any personal or detailed information about your particular situation or circumstance, because people will have access to the chat. And again, we'll be able to go back and watch the recording or view this live. So we want to try to protect your privacy as best as we possibly can. So we do try to ask that you keep your questions to be general in nature. If you are joining us on Zoom, please feel free to type whatever questions that you may have into the chat. Ms. Jessie is really good about kind of answering the questions as she's going along, but otherwise, your questions will be addressed at the end of the presentation when we're finished. If you are watching us on our social media channels, then please feel free to type your questions into the comment section And I'm monitoring those social media channels, so you'll have the opportunity to ask your questions there, and I'll make sure that it gets read aloud. For a couple of people that did email a couple of questions to me, I will put those in the chat for Jesse to go over, or for us to make sure that we get those addressed to at the end of the presentation. So, without further ado, we're going to go ahead and get started. There's other information. Our calendar for the month of August has already been scheduled, so there's other workshops and things that we've got that are coming up that I'm going to go over at the end with you, so that you all have the opportunity to get take an even deeper dive, so to speak, into the world of a month of service. So thank you all very much for joining us. And without further ado, I'm going to turn it over to Miss Jessie Campbell with Lone Star Legal Aid, so we can get started with the presentation.
Mhm. Thanks, Nia. Good afternoon, everyone. Thank you so much. Let me get my screen share started. And get me all situated. So that way. Wow.
Yep, you're good.
Fantastic. Okay. All right. My name is Jessica Campbell. As Ms. Nia said, I am with Lone Star Legal Aid. I'm a directing attorney, and today we're going to be talking about how to draft your own wills and transfer on death deed. So this is going to be part two, but first let's talk a little bit about who I am. So Lone Star Legal Aid is a civil legal aid organization. So what that means is that we provide free legal services to qualified households, and qualified is based on income and assets. And so I wish I can tell you how much that is, but it's complicated math. We have to find out how much you make based on how many people live in your household. And but it is based on but if you qualify, we do assist with civil legal needs. That is a variety of different types of issues, including consumer, family law, that's divorces, guardianships, custody, healthcare, housing, landlord tenant, public education, public benefits, estate planning. That's what we're going to be talking about today, and probate, just to name a few. These are just some examples of the types of things that we can assist with. We serve 72 counties in the eastern and Gulf Coast regions of Texas. So basically the eastern third of the state of Texas, plus 4 counties in southwest Arkansas in the Texarkana region. We have 11 offices, including Houston as our headquarters. That's where I am located. Um, and then we also have 11 branch offices that you see located there. And so our region is pretty wide. And so, if you know people who may need assistance, not just obviously here in Houston, but in our area, we are here and available to assist those of you, again, who are financially available for assistance who need this. All right. So just as Ms. Lee already said, today's presentation is for educational purposes only. I am not here to provide you with legal advice. I'm just here to educate you and provide you with legal information. So that way, if you do need to go seek legal counsel, you actually have some information that you can take and know so that you are informed and you can go ask the questions that you need. So that way you can hire an attorney, or if you should come to Lone Star Legal Aid or another legal services provider, that you are able to know what you need to do so you're a better informed client, and you can be able to do that. If you have specific questions, you really should go seek an attorney. I cannot answer and provide legal advice today, period. So if you do decide that you're going to ask a question today, know that I cannot advise you today. So don't ask me those questions. I don't mean to be mean. I'll be like, nope, can't answer that question. One, because I'm not your attorney. So usually I need a lot of information to be able to provide to that. And plus you have to be my client. And so you haven't hired me. You haven't been qualified for services with my organization. And so I cannot do that. Um, I cannot provide that for you today. And plus, we are in a public forum, as Ms. Nia says. Everything is out in the open. I do not want you sharing any of your private information today for any particular bad actor who may want to be able to take that and do something with it. Although I believe that most people are not bad actors, there are those individuals out there who may do that. So please don't share any private information when you are asking those questions. But I will be able to answer questions that are informational in nature. And so just be kind of aware of that as you are asking those questions. I do ask that you are welcome to put those questions into the chat for those of you who are in Zoom. If you are on watching it on the other platforms, again, Miss Nia is watching those comments and she'll put them into the chat as well. But if you prefer to ask a question verbally in Zoom, I ask that you do wait until the end. But I'm pretty good at answering questions in the chat as we go. Okay. So our agenda for today, so this is part two. So if you missed part one, the recordings are available. So please go watch part one. Part one, we go pretty deep into talking about what the documents are. What is estate planning? The difference between estate planning and probate. They are different things. Estate planning is the before, probate is the after. Before a person passes away, probate is after a person passes away. Two different things. We talk about what the different documents are, what they do, why you need them, what the roles are. So much more, it's a different type of information. We're not going to be covering any of that today. Today, we're going to be talking specifically about drafting, how to do about drafting your own will and your own transfer on death deed. And in fact, the majority of the time today is going to be talking about how to draft your own will. In fact, about an hour and a half is going to be spent talking about drafting a will. And then a little bit of time is going to be talked about how to draft your own transfer on death deed. If you don't know what I'm talking about, like what's a will, what's a Todd, then you probably need to go watch that first video because we're going to be talking about what those documents are very briefly so that way you understand when we start talking about drafting those documents. Because then you can't stay, you can stay and listen to them today, but I do recommend you go and listen to that part one as well. But today we're going to go over, if you have listened to part one, some of this information will be a little bit repetitive because we are going to repeat about how to choose your representative because you need to know how to do that when you're writing your will, right? So we're going to talk about choosing your representative for your will, your executor in your will. We're going to talk about the wills, what they are, the different types of wills. Then we're going to talk about whether or not the pro se will works for you because we're talking about drafting your own will today, whether or not using the pro se will, the template that we're going to be talking about today, whether or not that's right for you to use and whether or not you should be using it or whether or not you should go and seek an attorney to help you write a will. And then we're going to go through the form itself. Then we're going to talk about transfer on death deed, and then we're going to briefly talk about how to write your own other advanced planning documents that are available. All right. Okay, so now let's talk about choosing your representative. Every document that is an estate planning document has a representative, an agent that is standing in your shoes in making your own and making decisions on your behalf when you're not able to do so. For today, we are talking about the executor. That is who we're talking about. An executor is the person responsible for administering the estate. So that is the role that we're talking about in the will. So, but when you're choosing an executor, it should be someone you know and trust and will do what is in your best interest or as you would do in the situation. This is going to be true for any of these agents, any of these representatives that you pick, but that's going to be the role of the executor. Okay. And it's going to be, you're going to choose one person. You're not going to have shared authority. This person is going to be running the show. They're going to be responsible for all aspects of handling the affairs. So what is the role when you're thinking about what an executor does? An executor is going to be working with the attorney. There is an attorney. You cannot do a probate in the state of Texas with a very minimal exception. And it's minimal, it's a small exception. But even in that small exception, your executor still has to go talk to an attorney to see if they qualify for that exception. So this is the person that you're going to say you're in charge of going and starting the process and finishing the process. So they're going to be working with the attorney. They're going to file the documents with the court with the attorney. They're the ones that are going to be dealing with the creditors. They're going to be going and talking to the creditors, paying the debt or negotiating for non-payment of debt if that's what's happening. They're going to be selling the house. drafting the deeds, making repairs to the house. They're going to be the ones that's going to be arranging for a garage sale. They're going to be dealing with family disputes. If there's going to be specific items that are going to be handed out to individuals, it's like, okay, who's getting grandma's rings? I talk about grandma's rings a lot when I do these kinds of talks, and it's just like grandma's pearls, earrings, and grandma's rings. Well, maybe grandma has got three different sets of pearl earrings. Maybe grandma's got three different rings, you know. Well, who's written which ones, right? And so executors are going to be responsible for managing potential conflicts in family disputes. They're going to be responsible for taking care of that. If there's minors, there's a possibility that that executor is going to be stepping into the role as a temporary trustee, maybe the permanent trustee of managing property for a minor that all of a sudden is inheriting property that might not have been originally planned in the drafting of the will, and maybe a person stepping into that role. So this is an important role because of all of these, all of the things that they're going to be responsible for doing. There can be paperwork. There not can be. There's a lot of paperwork. They have to do taxes. They got to do the final taxes for the person who passed away. They got to do taxes, the final income tax, like the actual income tax that there's things. There's also estate taxes. The estate taxes have to get filed potentially, and so we're not talking about something that is necessarily an easy process. It's not necessarily a hard process either. It depends very much on what's happening in the estate, but you have to be aware that it is to some degree a job and that there's responsibility associated with it and that they have to be willing to do that work. And so it can be a difficult decision to make. And so when I talk about like when you're choosing this role, this can be very decision paralysis and can sometimes step into it can be a problem, right? Because you it's a loving decision sometimes, right? Because most of the time, majority of the time, the people who are chosen to serve as executors are family members, and it's really rare in my experience and working with my clients. And I think it's probably, I don't know, I don't work with, I work with my clients, but I do think that many people tend to choose family members, usually spouses or children or things along that lines, right? That it's like, oh, well, this is the person I love, this is the person I trust to take care of my affairs. And but sometimes that might not be the best person, right? It still might be a family member, but it might not be the quote logical choice, right? And so, for example, if an elderly couple comes in, you may not want to choose your spouse, right? Because person may have just lost their life partner of 40 years. They may not want to be handling an estate, right? Managing these issues and things like that. So they may want to choose somebody else. Um, and there's a lot of like I kind of joke. I make some jokes about things like, oh, oldest child syndrome. I can make this joke because I'm the youngest child in my family situation. I'm the executor of my mother's will. And I always joke with my brother. It's like, well, clearly I'm the favorite, right? And then people are like, well, I don't want my children to think that like I love one more than the other. And so I make the joke with my brothers. I'm like, I'm the favorite. And my mom's like, no, she's not the favorite. And she gives me a slap when I make the joke. She's like, Jesse's the lawyer. She understands the probate. She understands what's going to happen. If a probate's needed, she's going to, she can deal with it. She's used to paperwork. She's used to dealing with the hard things. Let her deal with the hard things. So that's kind of an example, right? That's like, now I know not every family has a lawyer, but there's usually somebody in the family who may be more apt and more prone to be more attuned to being able to do this type of work after the fact, right? And so it's like, well, maybe Bob's a better person because Bob's an accountant or Bob really enjoys balancing checkbooks. And so he's really good at like handling this types of things. And let Susie, who is the oldest, who's best friends with mom, who's going to lose best friend. Not that Bob doesn't love mom, but Bob is going to be like, this is going to be my gift. I'm gonna I'm gonna let Susie, you know, learn a new normal, learn a new life without best friend mom. And Bob is going to take on this is how Bob's going to help Susie, right, live this new life, right? So kind of take that into consideration when you're trying to pick the individuals. Discuss the decision with the people so that way they are aware what's being asked of them, and give them an opportunity to ask questions about how what the will says, what you mean by things, so that way there's no confusion about what is going on. Explain the decisions with the alternative as well. You're going to have alternates chosen. Just as important, I think, is also having conversations with the people who aren't picked, right? If Susie's expecting to be the executor because she's the oldest and is mom's best friend, and she's like, oh, she's like, I'm gonna be the executor. The oldest and the best friend. I'm clearly the one that she trusts the most to handle her affairs. I'm the medical power of attorney. I'm the statutory power of attorney, but I'm now not the executor. You need to tell Susie that, right? Don't let that be a surprise to Susie when you're no longer around to tell Susie that she's not the executor. Explain, Susie, I know I trust you more than anybody. You're my best friend. We do everything together, but I'm not going to be here. You're about to live a whole new life that you're not going to know what to do. Bob, who loves the balance checkbooks, has offered to do this, has a gift to you, it's a loving gift for us. Uncle Bob's great. It's a love. This is love. My love for you is letting me do this so that way you don't have to worry about writing checks and going to court and talking to credit card companies, right? So explain it just as much as important to talk to the people who are doing it, who's going to be doing the role. Talk to the people who are not doing it so that they understand why they were not selected for the role. People in the waiting room, let me get them in. All right, so let's go into the will. All right, so what does a will cover? So it's easier to talk about what a will doesn't cover, and then because then it's everything in the negative. So first there are non-probate assets. So will does not cover non-probate assets. We're going to cover this pretty quickly because I talked about this in depth in part 1. So please go watch part 1 because I go doing this really, really quickly, but in part 1, I go through it really, really in depth. So non-probate assets include retirement accounts. Those are IRAs, 401ks, those types of financial accounts. You're going to designate a beneficiary. Life insurance proceeds, again, you're going to designate a beneficiary. Payable on death accounts. Those are types of accounts that you hold at your banks, so savings account, credit card, the savings, checking accounts, credit unions as well. Those are types of accounts that you designate at your bank, where upon the death of the account holder, it automatically transfers to the named beneficiary. Those are actually really useful and very beneficial because for a lot of estates, there's really only a handful of property that gets passed via probate. And if you're trying to minimize the need for probate and potentially bypass the need to go to probate altogether, one of the ways that you can do that is to have your banking accounts, your checking and savings accounts be payable on death accounts. I talk more about this in part 1. I'm not going to go into too deeply into this. Don't ask me questions about talk more about payable on death. Go watch part 1 or come to my October presentation on it. But the payable on death accounts is something to consider. And then joint tenancies with right of survivorship where the survivor receives the property. So non-probate assets pass outside of the probate process, and so they're not going to get covered under the will unless for some reason the beneficiary listed is not listed, or there's some reason that the right of survivorship or the survivorship or the beneficiary listed doesn't pass. It does not go, the property doesn't pass under that, then it will become a probate asset, and then the property will pass under the will. So again, non-probate assets not covered under the will. Everything else is considered probate asset and it gets covered under the will. Okay. And so be sure that your non-probate assets are up to date with the main person. So as you are updating your documents, you're going to go double check your non-probate assets. Types of wills. So 2 types of wills when you're writing your own will. A holographic will, that's just a legal terminology for a will that's 100% written in your own handwriting. You're going to take out a piece of paper, you're going to take out a pen, and you're going to write it in your own handwriting, like all the way through. I, Jesse Campbell, write this is my last will and testament. I give everything to Bob, remainder to Susie. I name Bob as my executor. Sign and date, Jesse Campbell. That's a will. It's not a good will, but it's a will. Okay, and that's it. That's all it takes to be a valid will in the state of Texas. 100% my own handwriting. It's optional to have two witnesses over the age of 14 who are disinterested, and it's and a self-proving affidavit are also optional. An attested will is a will that's 100% typed. You're going to take out a computer, or if you're fancy and vintage, you can take out a typewriter. You're going to clickety clock, type everything out, and then you're going to print it out, and then you're going to sign and date it as your will. This one requires two witnesses over the age of 14. Everyone watches each other sign it in everyone's presence, eyes, balls, and everyone. We're going to sign and date it. That is what is required for a valid will in the state of Texas for it to be typed. And that is what is required for it to be a valid will. And it's optional to have a self-proving affidavit. So what is a self-proving affidavit? A self-proving affidavit is a separate affidavit that is signed and dated at the same time in front of a notary. Notaries are not required to have a will be valid in the state of Texas. It is a separate step that is done with the will that removes the requirement for witnesses to come to court to prove up a will, to prove that the will is valid is a separate step, is what the self-proving affidavit does. And so that is done with a notary. That is, again, all the signatures done with the notary watching. And then that's what the self-proving affidavit is. Again, I go into great detail about the difference between the holographic and the attested will in part 1. So that's just kind of a quick overview of the difference between the two for today's purposes as we go into the fill in the blank, as we go into the pro se wills that we're about to talk about. Okay. Now, there is an exception when it comes to the fill in the blank wills, the hybrid wills, which is what we're about to talk now, which is the Supreme Court forms. There is no fill in the blank wills in the state of Texas. Okay. You either have to be 100% handwritten in your own handwriting, or it has to be 100% typed. Okay. So you cannot go to some big box store where there's a fill in the blank will where you pick that up, or you go online and you find some will where you print it out and then it's like there's lines and then you write it in your answers into the blanks. Those wills are not valid in the state of Texas. Not valid. Period. So do not use those. Period. Okay. There is an exception for what we're about to talk about, which is the forms by the state of Texas. It is also, while there is an exception, I really hate saying that because you're going to hear, oh, an exception for fill in the blank forms. No, fill in the blank wills are not valid in the state of Texas. So in my opinion, you should not do it. So even though there's this form for the state of Texas that the Supreme Court of the state of Texas has created, you should still type up that will and print it and do that, because I don't want you to walk away from this meeting hearing fill in the blank will is okay. Fill in the blank will is not okay. If that's the only option available to you. But if you have a computer using the Supreme Court forms, you should still type it up and print it and sign and date it. Okay. So, but it's still not recommended. Technically, the way the law is written, it's not, you still have to have it be fully typed. So I do recommend, even if you have the computer, typed up the will for the Supreme Court forms and print it and then execute it according to the laws of the state of Texas. All right. Pro se will forms. What does pro se mean? Pro se means doing it by yourself, representing yourself is what pro se means. And so the Texas Supreme Court, so the folks in Austin, these are our Supreme Court justices that we elected, have approved a will, simplified wills that for people to use for themselves. There's 4 forms: a person who is single, widowed, or divorced who has children, a married person who has children, a person who is single, widowed, divorced who does not have children, and then a married person who does not have children. It is both in English and in Spanish for each of these forms. All right, so here's the big one, the big question. Can I use this form, individual plan? Maybe. It's really important to hear and important to know that wills are individualized, and that you really want to be sure that you do a will that works for you and your family and the needs for you and your property. These forms are very simple. Very simple. And they're not intended to cover every scenario that you can think of. And almost always, every time I do this session, I get questions about, I would like to try to do this. Can I do this with this form? And almost always, the answer is going to be no, because the forms are not designed for exceptions. The forms are designed for general, big picture, no exceptions. They're not designed for nuance. They're not designed for a special case scenario where we really are thinking about like one particular thing. We're not thinking about looking around corners where what ifs might happen. We're not thinking about like special needs. We're not thinking about like, that's not what these forms are for. If you have a unique situation for your family, you cannot likely use these forms. So let's talk about that, right? So you need to disinherit somebody, your family dynamics. You need to disinherit somebody, not this form, right? Like if you need to actually disinherit somebody where you're like, I need this person cut out of my will, this form does not have a disinheritance clause in it. There's language. You have to use language to disinherit somebody. This language does not exist in this will, right? So you need to think about your family dynamics and who the family members are. How, are there people who are not part of your family member that you need to include? And you want to include them in a certain way. There are people who are constructively adopted, people who are not legally part of your family, but you view as part of your family. If there is no legal relationship, just because everyone else in the world thinks of them as part of your family, does not mean the law will think of them as part of your family. So you got to think about that kind of thing, right? The type of property that is owned. Do you have real property, land? Where is it located? Texas law, we are only talking about Texas law. The will only really will apply pretty much in Texas. There's different nuances when we're talking about when land is owned outside of Texas and your property outside of Texas. Doesn't mean that you can't write something here, but we have different things to consider. You have to think about different things, right? Different states have different laws, and so you might want to have to talk to an attorney about that. Who is inheriting? Do they have special needs that have to be taken into consideration? Living with a disability and receiving government benefits based on income, you must specifically plan for that, because inheritances can disqualify that person from receiving their government benefits. There's ways to work around it. Sometimes you can't, but depending on what's going on, there are ways to work around that so that way we don't lose our government benefits. And and now maybe the inheritance is big enough that we don't care. Sure, whatever. They're going to get millions of dollars. We don't care if they lose their government benefits. But if the inheritance is a small amount, and we don't want them losing their government benefits, so we want to make sure that we're doing things to protect that. Well, these documents are not going to do that. So we need to be sure that we're thinking about that. Do we have people living under a guardianship? So that's adults living under a guardianship. We need to be thinking about that. Minors under the age of 18, minors cannot hold property outright. So we have to have things in trust. We have to think about how we're going to do that. How they're going to inherit, when they're going to inherit. This is their debt. Is debt owed? Is it secured property? Is there a mortgage, reverse mortgage, car loans, other types of debt that we need to be thinking about and preparing for? So everyone, debt, we inherit property subject to debt. The state is responsible for paying the debt, but if there's secured loans, we inherit that property. There can be planning for it. You may need to plan for that in your will. You can claim for debt in your will, but these documents are not, the simple will is not going to take that into consideration. And so depending on what you need to do, again, these wills might not do that for you. These not might not. These wills will not do that for you. And so, of course, then there's special instructions. There's other types of things that people can do. There's life estates. People do create life estates for folks. Maybe you are on a, you know, so an example of some special instructions that may exist would be things along the lines of, um, I, you know, multi-generational household. So say, for example, Susie is living with mom because mom needs some extra care. And so Susie has moved in to help take care of mom, but Susie has got her own two kids living with her and living with them. So we have a multi-generational house. And so mom wants to make sure that her two grandkids, Susie's grandchildren and her grandkids, can stay in that house until those kids finish school because it's a better school district. They, they've made friends, whatever the reasons are, there's a pool in the backyard, whatever, right? But mom's like, I want my grandkids to be able to stay here as long as they want to, and I want them to be able to stay here at least until the little one graduates from school. And so, but the house is going to go both to Susie and Bob. Those are the instructions. Susie doesn't own the house by herself, but she can live here as long as the two little ones are in school. That's an instruction. That's a life estate. And so, and so that needs to go into the will if you want that to be enforceable. Otherwise, Bob can kick Susie out if he really wants to. If, you're trusting Bob, even though he's really good at being an executor, maybe he's not so good at maybe he wants to sell the house. Maybe he needs the money. Maybe he owes money and we don't know about that. He hasn't told anybody about it. The only way to make that enforceable, I'm making Bob sound sinister, aren't I? He may be good at balancing a checkbook, but maybe he's not, but I don't know. Family has secrets, right? So, but we don't know. We don't know what's going on. If you want that to be enforceable, if you want to make sure that Susie definitely can stay in that house till those little ones graduate, that's an instruction. So you have to be able to put that into a will. These pro se form wills are not going to be able to do that. So you need to be able to think about, like, what is it that you're trying to accomplish? Sometimes people want to do things because they're trying to save money and they're trying to think about, like, well, I'm trying to make things easy and I'm trying to do like what's best. Like I'm trying to avoid probate because it's going to save money, right? Like, well, no. Sometimes you need to do a probate. Sometimes doing the probate is the cheaper thing to do. Sometimes that is the best thing to do because it's going to avoid the conflict. It's going to make it to be the most effective way to do it. Sometimes the probate is what you need because it's going to be the most efficient way to get to the solution of what you're trying to do. Similarly with writing a will, right? Like just because a pro se form, just because a form is available and it's free, right? Just because you can use it doesn't mean it's the right one, doesn't mean it's the best one, right? Sometimes you need to go in a different route. Sometimes you may need to hire somebody to write the best document in order to make the next step when the time comes to make it the most efficient so that way you avoid the conflict, avoid the expense of an expensive probate, because having a well drafted will that actually really lays out everything that you need and it really makes sure that everything is done right will actually save your heirs and your estate money at that stage, by making sure that everything is written in such a way that it's well. And more importantly, I think it actually will save the family from the conflict that can arise from a badly drafted will. That can, because they're fighting each other because they don't understand what the instructions were and what they want. Because even though you've selected an executor that you trusted and you explained everything to, and they're doing exactly what you asked, it doesn't mean that the person that everyone else is going to understand and is going to be like, well, we agree with this, but you're still making it not what we want, right? So, and because because the executor still has to do what the will says to do, the court still has to do what the right what the will says. There's some leniency, but there's only so much you can do when the will is not clear in its instructions. So it's better to have a well drafted will that has clear instructions than using a form that doesn't tell you, that doesn't give you what you need. Okay. With that, let's start talking about how to use these forms. All right. Miss Nia is going to send you all of these documents, all these things. So don't go frantic trying to take notes or anything along that lines. All right. So you're going to get links. You're going to get everything. I did try to use the most commonly portions of each document. So that depending on which form you use, obviously married people with children, you're not going to have the children section in the single forms, right? So, but for the most part, we're just going to kind of cover everything and explain what each section is, right? So section 1 is the identification section. That's exactly what it is. It's saying who you are and what this is doing, right? So, again, you're going to fill in the blank, preferably on the computer. You're going to type it in and then you're going to print it. But this is that exception. You can do this by hand, but this is an exception. This is the only one, the only form you can use as an exception. Do not use anything else. All right. So you're going to write your name, your full name. You have used different names. If you have an alias, whether or not you have, whether or not it's a legal name change. If you have legally changed your name, put that in. But even if it's not a legal name change, even if it's just you go by a different name, you're also going to put that in here. Has what you also go by, right? So that's going to be 1.1. This is 1.2 is you're declaring it has your will and you're revoking any other will. If you're using the married form, it's going to have you are married to, and that anything after that is going to be referring to has your spouse. And then if you are, if you have children and the form with the children, it's going to have a section for naming who your children are. I don't have the box, but it's basically been a box that has all of an area for you to list all of your children. Okay. All right. Then we're going to go to section 2. This goes a little bit, in some degrees, a little bit illogical, out of order, but you just kind of go with it. Remember, read the form. The form is giving you the instructions. You're just going to follow the instructions as you read it. But the recommendation is to read it all the way through for the first one. And then I would have 2 copies. I would have a draft copy and then maybe worthwhile to print one copy up and go through and make notes on it and make sure that you have what you want, and then maybe go back and then type it up as it's correct, because right, this can be a confusing document, right? You take your time. You're not in a hurry, right? So you do that. So section 2, everything I own except the specific gifts. So this is kind of like you have choices. So you're kind of picking what you want, and you can choose option 1 or you can choose option 2. So this is everything you own. So this is your separate property plus your half of community property. So this is if you're married, right? So if you're married, this is everything you own. So if you're married, community property, you own half of everything you own of community property. And your spouse owns the other half. So this is you're saying except for the specific gifts. So you're saying grandma's ring, right? That you're giving everything to your spouse. That's what choice 1 is you're giving everything to my spouse if they survive me. If my spouse doesn't survive me, so that means your spouse has passed away first. So your spouse passes away first, then everything to my children. And right, so then everything to my children, and it will be divided equally among their children. There's nothing, no other instructions here, right? So if you got 2 children, they're each getting 50%. You got 3 children, you're each getting a third. There's no special instructions there. Everything is equal. And then if any of your children should not survive you, then their children will get their share. So for example, Bob and Susie are our children, right? We figured this out. Bob and Susie are our children. So, if my spouse doesn't survive me, then my share would go to my two children, Bob and Susie. But what happens if Bob should pass away first and he's got 3 kids? Well, then Susie would get 50%, and Bob's kids, all 3 of his kids, would share Bob's 50%. That's basically what is happening there under option 1. And if you pick option 1, you would sign option 1. Or, again, this is still married. We're choosing married. Or you would pick option 2. Even if my spouse survives me, I want everything to go to my children. The same thing. Everything divided equally to my children, and if one of my children should not survive me, then their share to their children. So even if my spouse survives me, so my husband's alive, he's cool, my children are going to get it. Bob and Susie are going to get it. He's just going to, my husband, I don't know, he's just going to fend for himself. All right? That's okay. People do this. People do this, right? Why do they do it? Various reasons. It could be a spouse from it could be a second marriage or a latter marriage. The children are from a previous marriage and they want their children to go and inherit it. It could be an older couple, and they're just going to go ahead and bypass the spouse inheriting the property. And they're like, well, we're already 90, so why have it go to the spouse? Might as well go ahead and have it go straight to the children, and just go ahead and avoid having to go through this process multiple times. So let's just go ahead and have it go through their children. There's various reasons for it. And so there's no right or wrong here. It's just whatever you're choosing for what's best for you. Right. So, but then if you want option 2, which is that it's just going to go straight to your children instead of to your spouse, then you're going to choose option 2. Right. So simple for everything I own except for my specific gifts. All right. Now, if you're single, and the single one, so we just talked about married, and if it's single, everything you own, you just list who you wanted to go to. This is everything I own except my specific gifts, except grandma's rings, right? This is everything I own. You're just going to list who you want. You wanted to go to Bob, you're going to go to Susie. Well, I guess not Bob and Susie because those are my kids, right? But it's just like, right? But if you wanted to go to, Angelina, I don't know who Angelina is, but Angelina, my best friend Angelina, you're going to list Angelina, right? So you're just going to list whoever it is. Easy peasy, right? All right, now we're going to talk about specific gifts, the individual items. The first one is going to be your home. So again, we're just reading this. You're just going to always read it because it's saying exactly what it is. These are not out of the blue. These are not meant to be confusing. These are meant to be straightforward and direct. When you get to section 3, now this is the same for both married and single, right? When you get to section 3, we're talking about specific gifts, and it's going to be my home. So that first one is going to be my home, subject to mortgage and liens. Remember, when you inherit secured property, we inherit it subject to the debt, subject to the loan, the mortgage, and reverse mortgage to the following person, and whatever you list there. If it's Bob and Susie, Angelina, whoever it is, if there's 3 people, they each inherit 1/3. There's no special instructions here. Everything is divided equally. Okay. We're going to talk about Todd's at the end, but a Todd will take precedent over a will. Todd's priority over a will. So if there's going to be a Todd, you don't have to worry about this. You can just leave the section blank. Or if there's, but otherwise you would just list who's inheriting the house. Okay. Now, if you want everything to go to your spouse, including the house, you don't have to put the section is because everything will go to your spouse. Now it's going to be your personal and household items. Same thing. Each person named gets an equal share. Now, The thing is about this is that the executor will have the ability and the authority to let people kind of go through. This is not specific gifts, by the way. This is just general, right? So this is like everyone, like this is all your furniture, your pots and pans. This is everything. All your personal property will each get a specific gifts. But your executor will kind of be able to be like, oh, you can go in and pick what you want and that kind of stuff. Like they'll be able to do that. But this is not specific, guys. This is not grandma's rings. Again, we're not talking about grandma's rings. This is just like everything. So, and then there's like, oh, then we can have a garage sale. And then the amount is split equally among whatever is remaining. So that's what we're talking about when we're talking about personal and household items. It's like you don't have a specific item in mind for an individual, but the executor can be like, come in, take what you want. Anyone disagrees about who gets a certain item, executor makes that decision. Okay, you can get that coffee mug and you can have that coffee mug, between the two of you. And so, but that is what this section would be on the personal and household items. And now what we have after that is the individual items. Grandma's ring. Okay. Now we talk about grandma's ring. Now what happens if grandma has 3 different rings and 4 different pearl earrings? You're going to have to be very specific. You're going to have to be like, well, grandma's antique diamond ring that we have. Well, if she's got 2 of them, then you're going to be like, well, it's grandma's engagement ring that she got from grandpa when they got married in 1915. And then there's grandma's anniversary ring that she got on their 30th anniversary that, and, and then you have to hope that the executor knows which one's which, right? Of course, you're going to want to let your executor know because your executor, whom you've picked because you trust and will do exactly what you told them to do, will know which one's which and who it's going to go to. And of course, you want to be sure that the name of the person is clear. Now, in my family, for whatever reason, I do not know why, every single man is named John or James. I'm not even kidding. When my husband and I got married, if you called that John or James, 2/3 of the men in the room turned around. So you needed to be very specific about which John or James you're going to be talking about. And so, family names, right? We have family names. And so if there's multiple people with similar names, you're going to have to specify which one you're talking about. So you're going to have to specify the item specific so that way there's no confusion. And you're going to have to specify the individual with no confusion. Even though you're telling your executor what you mean so that way he or she knows that they know exactly what you're talking about, your will needs to be specific. Because if there's still a contest, because even though your executor knows what you're talking about, if someone says, no, I want someone else to do that, and the judge has to now decide, which hopefully doesn't happen, right? You don't want a judge deciding something like this. But if a judge has to decide, you want a judge to be able to read that and be like, oh, I know exactly what this is talking about, right? So you're still going to want this to be clear and descriptive about what the item is and who the person is that's receiving the item. Okay? But the executor ultimately will be the decision maker in most cases. Right, that's it. So you see what I said about like the wills are not intended to be you're not going to be able to go in and like write like a paragraph here. If you're going to try to write a paragraph and you're going to make a mistake and you're not going to be able to make it really very clear. This is not meant to be create, a whole theme of instructions. It's just to see, I want grandma's diamond ring from her engagement to go to Susie. I want grandma's 30th anniversary diamond ring to go to Bob. That's what this is intended to be. Okay. Now we're naming the executor. You're going to name the executor. Again, I've already talked about who this role is and what they're doing. They are required to be 18 years of age, and the court must approve this person. And so if the person does have to qualify, and there are reasons the person can be disqualified, but if you have reason to believe that they might not be able to qualify, you should probably talk to an attorney. But it's usually there's some aspects of criminal history, fiduciary reasons, so financial crimes, things along that lines that might be a reason for that. But they do have to have be able to serve, be bondable. Basically, they have to be bondable. Um, and so you're gonna have your first choice. You're gonna list Bob. Your second choice is gonna be Susie. You can have a third choice. I don't usually have third choices in my wills, but you can have a third choice if you wish. And then you're going to say, and then it's naming an independent executor. What an independent executor means is that there's no be no court oversight. We don't want the court to be involved, right? We want our executors to be able to do what they need to do without having to go back and asking the court for permission. That's what saying an independent executor is that we're letting, once the court has approved the executor to serve, then they can go in and be able to do that without having to have permission to do so. All right. So even though I just said they have to be bondable, we don't want them to actually have to post bond, right? So 4.2 is saying that we want our independent executor to not be required to post bond, so we can save some money and we don't have to post bond. And then 4.3 is talking about the powers given to the executor to settle the estate, basically saying, hey, I want the executor to do what they need to do to settle this estate, including paying the debt and selling property. We need to be able to do this without having to consult anybody. So that way they're not like being, their hands are tied from being able to do what they need to do. And then 4.4 is basically saying is explicitly saying that we want this to be an independent administrations, that the court will not take any action except that which is required by law, which is essentially probating and recording of the will, notice to beneficiaries, and the required inventory appraisement and list of claims. Those are the actions required by law that the court must take. And so those are the actions that the court will do in this administration. And then we go to section 5, which will be dealing with children, if children should inherit. This is always going to be included. Like sometimes you're like, oh, do we have to include it? There's always a possibility that children may inherit, right? Because of those clauses up there that we have about like what happens if a person should pass away before we do. And so there's always the potential heirs. So the potential heirs who may come in after the fact, right? So someone who passes away before we do, and then their heirs may take. So there's always a possibility that a minor may inherit. So we don't take this language out. We always include minor language. But also, you may have a child. You may have put, your 13-year-old as an heir. You may have listed them. And so then in which case we need to include how the property is held for that minor. And so this is basically the section that talks about how property is held for minors. Anyone under the age of 21 is basically saying that the gift is going to be held in trust for them under the Uniform Transfers to Minors Act of Texas. The executor will name the custodian. The executor may appoint the surviving parent. The executor can name different custodians for different beneficiaries, and the executor themselves can serve as that custodian. All right. Section 6 is when there is a guardian of a person of a minor child or incapacitated adult. Obviously, this is only going to be in the documents where you have children. If you are the documents where there's no children, you're not going to have this. And this would be naming a guardian who's going to care for that incapacitated adult for whom you have a guardianship over, as well as your minor children, who's going to be taking care of them. This is going to be naming your first choice and your second choice. The court must approve this person, but they will take very much into consideration the person that is named. So obviously you would think of who you would want to serve in this role. Section 7 is it says that Texas law applies. Obviously, we're in the state of Texas, only Texas law applies. If you have property in another state, the laws in those states applies. I cannot tell you anything about those 49 other states. You have to talk to an attorney in those other states about what needs to happen in the planning of those, in the estate planning for those states. And then 7.2 is a survivorship clause, which is that a person has to survive for 30 days in order for them to take under the will, in order for them to be considered a person living under the will. So remember when it says that if a person doesn't survive me, then who will go to after that? Basically, they have to survive 30 days afterwards. The intention of these survivorship clauses is to prevent what can be effectively very complicated, successive probate situations. And so this is basically what it's just creating a survivorship clause for 30 days to kind of minimize those potential successive probate situations. And then we get to section 8, which is about the execution, attestation, and the self-proving of the will. And then here is not where you are signing. Here you're just putting in your name and the two names of your witnesses. So that's where you're putting in the names. Remember, your witnesses have to be disinterested over the age of 14. Who are disinterested people? People who are not related to you by blood, marriage, or adoption. People who don't inherit, who do not benefit from the will, and who don't owe you any money. Like basically, they just don't care. Like, right? So who are good witnesses? Neighbors, co-workers, friends. Those are basically the best types of witnesses that you can have, right? So you don't want anyone related to you or a family member. They have no reason to, so that's who you're going to want. Those are going to kind of be your best witnesses. This is an attested will, right? It's typed. It's a typed will. So this is an attested will. It requires witnesses for it to be a valid will. You cannot do this as you cannot just sign this will by itself for it to be a valid will. Now, for those of you who are like, oh, Jesse, I don't have any witnesses. I need a will now. I am sitting on a ranch in a county where my closest neighbor is a cow, and that cow is 300 miles away from me. I won't see another person for another 1,000 miles away. I I don't know how isolated people are, but maybe someone's got to really write a will right now. And I told you earlier that you can do a handwritten will. You can use this template. You can use this template to do a handwritten will. You can take the language in this will and write it out by hand. Write each section. It's long. Your hand might be tired by the end. But you can use this template and write a handwritten will and sign and date it at the end and have a will in the state of Texas. I would like to avoid handwritten wills because those are more difficult to probate because you do have to have two witnesses come and be able to testify to your handwriting for a will. But some people are in situations where they, for whatever reason, are not able to do witnessed wills with notaries. And they really are in situations where they really need to do a handwritten will because that's what they need to do. You can use this will as a template to write a will, and it will have all the language that you need for a will. So if you are in a situation where you really need a handwritten will because you need one quickly for a reason, it's better to have a handwritten will than no will at all. Then use this as your template. So, but otherwise, this is an attested will, so it does require the two witnesses, and they do need to be disinterested over the age of 14. Right? And then this section is basically the attestation. It's basically saying that you are a testator, person writing the will, swearing, and the witnesses are swearing that this is your will, that you're making it of your own free will, that no one's making you do this will. Oh, excuse me. That you are signing it in front of witnesses, and that you requested the witnesses to serve as your witnesses, and that you are now signing it. That's basically what that is. Then you're going to date it and sign it. Remember, tested will, you have to sign and date it. Has to have a date. Be sure the date's on there. Right? And that's it. Oh, I remember doing this last time and I forgot. There is a notary box. There's a notary box after this. And I don't know why I forgot to add the notary box to it. There's a notary box underneath the signature where their witnesses are going to sign, and then there's a notary box. This is a self-proved will. So you're going to do this with a notary, and then there's going to be a notary box, and then you do it in front of a notary. Now, so this is really important to know. Not all notaries will notarize a will. So you can't just go to any random notary. I happen to be told, and I think this is still true, I haven't checked in a bit, but UPS notaries will not notarize wills. Some banks will do it for their customers, not all. So you have to check with your bank. Just be aware of that. For those of you who are in Houston, as part of the month of service, and our CDC will help with notarizing these wills. So that information will be part of your email, and there on how to schedule those appointments and times to be able to do that. But just be aware when you're doing this and you're like, oh, I now need to do a notary, the signatures and everything. Remember what I said at the beginning, everyone has to be looking at everything. So the witnesses and the notary all have to be doing the signatures at the same time. So you can't sign it and then take it to your neighbors and be like, oh, I already signed my will. Now neighbors, I need to do it. And then you by yourself without your witnesses go to a notary and do it. Nope, that's not how it works. All four of you have to be doing it together for it to be valid. You're all doing it at the same time. Okay. For it to be a valid will, but that's it. So, but you're going to see this is pretty simple. It's a pretty straightforward process. Now, as much as I talk about it, about being individual and like how it works, for a lot of people, this works. A lot of, many people do write very straightforward, simple will. Like most people who are married, when their children are the children of the people they're married to, a lot of their wills really do just say what this is, which is why the Supreme Court wrote it the way they did. Because most people give their property to their spouse in the event that their spouse doesn't survive them, then their property gets divided equally among their children. And so for a lot of people, this works. Again, but if you're thinking about those individual situations, which there's, plenty of people where this doesn't work, then just be sure that you are getting the counsel that you need. So that way you write the will that does work for you. Right. So now what to do, Will? What to do next? Not what to do next. Once you are done, you're going to staple the will. Once you do that, do not unstaple it ever, 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 because that can be viewed as a destruction of the will. Yeah, but if you do need copies, just do it without taking out the staple. Don't write on it. Don't do anything to it. Write on the photocopies. And if you do decide you want to change the will, do a new one, execute a new will. Because notes on it, scratching things out, things like that could be viewed as a destruction of the will, and that can be viewed as voiding the will. And you don't want to do that. You just did all this work to get a valid will taken care of. So you don't want to all of a sudden do something where someone else down the line that says, that's no longer a valid will. Look at that. He took out the staple. We don't know if they changed the page. That's the whole point, right? The reason why you don't want to take out the staple and do something is because someone can argue that they took out the page with the specific gifts and put in a new page with specific gifts. And that page is not the original page. That's what we're talking about, right? I'm a lawyer. We're always talking about like bad news things and like how things can go wrong. And so that's kind of what we're trying to avoid. And so that is kind of what we're thinking about, right? So you're going to be able to do that. All right. Okay. Oh, so there's can you add things or additional pages to the will? I don't know what the additional things are. You can add pages of like if you have more specific items, right? Like, so I don't remember how many lines they had available for like specific things, but if they only had space for like 6 items and you happen to have like 20 items of specific items that you want to have to that you wanted to add, you can do that. But you cannot add new pages to the will after you've executed the will. So that's what so yes. So no, you cannot do that, right? So um once you've executed the will, that will is now it's in its final format. So you can do what is known as a codicil to the will, which is that you can add an amendment, you can do an addition. You can do a codicil, which is like, oh, I now have new things, but now you have to do um, the same formalities has the will. So you have to go do the same thing. You have to add kind of the same language for a codicil, saying, I am now writing a codicil. You also now need witnesses with with a notary. It's the same process. For some people, they may think it's just as easy to write a new will as it is to do a codicil, depending on what the codicil is. But no, you can't just have, if you're adding a list, you can't just add to it. Some attorneys have different points of view on that. Some people will write a will that will say there's going to be a list somewhere, but the list doesn't have the same effect as a will. If you want the list to have a court of law of power, the power of the court of law, then it has to be done at the same time as the will. You can't just write it out and then just slap it on. So you have to have it either as a codicil or a new will, in order for it to have the same effect as where the power of the court will be able to be able to enforce it. Otherwise, it's just a piece of paper that may or may not be real. Um, is how the court will look at it. And could be contested, could be argued about. So, all right. Copies are not valid. Copies of wills are not valid in the state of Texas. They're, you know, so it's really important that you keep the copy of your will, not the copy, you keep the original of your will in a safe space and that your executor knows where it is. Is it possible to probate a copy of a will? Yes, but it is, but there's hurdles, right? Like there's obstacles. You have to prove that it really is the will, right? Like, but and sometimes you can't do it. And so it's really important to make sure that the original will is protected and safe. So what is that? Where do you put that? How do you make sure that your original will is safe? Couple of things you can do. You can file it with the county. You can put it with the county and it's safe there. And but you don't have to. That's an option, but you don't have to. Safety deposit box. You can put it in your safety deposit box, but really important to know this. The Once it's in a safety deposit box, in order to open it, the person opening it must be both an account holder and a key holder. They can't just have a key. If they're not an account holder, they can't open the box. And so um, otherwise, it requires a court order to open the box, and only the executor can get that court order. And so if it's not both an account holder and a key holder, you may not want to put it into the safety deposit box because again, you might need a court order to do that. Not a big deal if that's what you want to do, but just be aware that that is going to be what the situation is there. But otherwise, just where are your important papers? Where's your birth certificate, your social security card, passports, right? That's where my stuff is. So that's usually where I think most people would put their documents. Like put where your important papers are. Let your executor know. That's where your documents are. Okay. And then just as important, when the time comes, which will hopefully be many years from now, let your executor know they need to do something. You've done all this work. You've written a valid will. You thought about it. Make sure your executor knows they have to take that piece of paper. They have to take that will. They go talk to an attorney to make sure that they know what needs to be done after the fact. Okay. So that is it on the will. Make sure that I didn't miss any questions. Where my last one? Oh, there it is. I don't think I see any questions on this. Okay. All right. Transfer on death deed. Okay, now we're going to talk about transfer on death deed. Unfortunately, this document is a little bit more confusing, so bear with me, but it's more confusing just because of the way it's written, but We'll get through it. All right. Transfer on death deed, also commonly known as a TOD, is a way to transfer real property, land, and a house to someone else when a homeowner dies. This avoids the probate process. Remember what I mentioned and alluded to at the very beginning about non-probate assets and the payable on death deed? Well, for a payable on death account for your bank accounts, there are ways to avoid the probate process. Again, I talk about it a lot more in part one, but if you have a payable on death bank account, which is again a lot of people, that's a big one is their bank accounts, and there is um there is your house and a car. For most people, those are their big things that go through probate. Everything else is usually your personal property. Personal property tends not to have to go through probate. Um, and sometimes non-probate assets like your life insurance and stuff like that, but you got make sure that there's beneficiaries listed on that and things. But your house and cars are usually other things that are kind of the big things. But you know, I'm not saying you can 100% avoid probate, but sometimes you can. And for some people, not all people, a transfer on death deed is a really good option to pass your house on to your heirs and avoid the probate process. Okay. And so if it is, and I do recommend that you do consider, if you have the ability to do so, to talk to an attorney about it. Because again, just like the will, there are reasons why you don't want to do a Todd, right? But um but there are, but for if there is a good reason to do it, then you should, right? And so it does take priority over a will, which means that if you have the house in a Todd and in a will, the Todd takes priority. So if you gave your house to Bob in the will, but you then did a Todd for the house to Susie, Susie gets the house. Does not matter when that will was written and when the Todd was filed. If you did a Todd for Susie and then you wrote a will giving the house to Bob, Susie gets the house. If you wrote a will to Bob and then a Todd to Susie, Susie gets the house. Todd always wins no matter what. So if you change your mind and you want Bob to get the house, then you need to revoke the Todd for Susie and either do a new Todd for Bob, or you need to just revoke the Todd for Susie and then to write the will for Bob. So that's so it's really important to recognize that that the Todd is supreme in this particular situation. But the good news is that you still own the property. You can mortgage it, you repair, you can rent it, you can sell it. Like, right? If you sell it, then the new warranty deed takes precedent, will automatically revoke the Todd. So there's no harm to doing a Todd, other than if you change your mind about who you want to get it, you have to revoke Todd that's already filed and the costs associated with filing the Todd and filing a revocation. That's the biggest, you know, harm to it if you should not want to do it down the line is the cost associated with it. Assuming it's the right choice, the right document to use for your estate planning. You can only transfer the portion that you own. So if it's community property, it's the 50% that you own. And of course, joint owners is the actual percentage that you own. Property is inherited subject to any debt. So just because you've done it with the Todd, if there's a mortgage or reverse mortgage on that property, they still have to pay that mortgage. They still have to pay that reverse mortgage. There are ways that you need to be thinking about that to make sure that the beneficiary is able to either assume the mortgage or pay the mortgage. And there are factors to be taken into consideration for that because not every person inheriting property is able to pay that mortgage. So take that into consideration. Sometimes there is, again, as I mentioned, when it came to that individual plan, sometimes they're like, oh, the hyper focus is on avoiding probate. that they forget about the debt, and sometimes going through probate to pay the debt, being able to create a mechanism for the debt to get paid is a reason um, to go through a probate process. Although not necessarily, you don't necessarily have to do it. There's other ways to do it too, but there may be things to be thinking about. There it goes. All right. So again, we have a pro se, Todd, pro se, self-representing it, doing it yourself. There is a toolkit that's been prepared by the Texas Access to Justice Commission. It's available on a website called texaslawhelp.org. There's also an online form at that website. Again, this link's going to get sent to you, so you don't have to frantically write it down. This one is, you just type it in as you go. It's an interview. Basically, it's an online interview. So you're going to hit the buttons like yes, you're going to type in the answers. And then when you're done, you will have a completed form printed for you. So if you have online access and you're comfortable doing it, I highly recommend you use the online form. What we're going to go through today is using the toolkit thing, but it's the same information as the online form. And so just kind of be aware of that. So, but that way you know how to answer the questions as you are going through the online form. So when the Todd is filed, after a person passes away, a death certificate does have to get filed in order for the death certificate is filed, and then that's when the Todd is effective. And that's all you have to do for the Todd to be effective, to answer the questions. So someone asks if a Todd is filed to giving it to the surviving spouse, you have to file anything. You have to file a death certificate after the person passes. At the county with the county clerk, just what the same what after saying when you file the Todd, where you file the Todd, you file the you're gonna file when you're at the end. I'm gonna tell you what to do with the Todd. When the person passes away, you're gonna file the death certificate where you file the Todd. Yeah. Okay. All right. So property owners, name of the property owners, all must be included. So the form includes 2 people. If you have more than 2 people, you need to add page, adding the other people. So if 4 people own the property, then you need to add all 4 people. But usually, obviously, most of the time, there's 2 people who own property, or 1 or 2 people. Okay, so easy peasy. The property information. This is the part that's the hardest part of a Todd, is the property information. Okay, this is the hardest part. You need the legal description of the property. The legal description is not what's on your property tax statement. You need to get your warranty deed from your house, right? So you need to get your warranty deed. And um and so it's not the mailing address or anything like that. So you need to get your warranty deed. Sometimes you need to dig a little bit further, because sometimes the deed that you have, if you got your deed, like if you got a quitclaim deed or a gift deed for your house, the deed that you may have might not have the full legal description of the property. So you may need to dig a little bit more and go a little further back and get a more accurate legal description. So you need to get the legal description of your property, but the best way to do it is to get the deed from when you purchased the home. But if you inherited the home, you may need to dig a little bit deeper. But if you bought your home, usually whatever is on your warranty deed is usually what's sufficient. If you did not buy your home, you may need to dig a little bit more. You may want to talk to somebody if you did not buy your home about the deed, and looking at your deed to see if your legal description needs you need to dig a little bit deeper. Okay. So you're gonna get your warranty deed out, and you're gonna copy the legal description from your warranty deed into that box. If that is not big enough, then you're going to get another piece of paper, and then you're going to write like see attachment, and then you're going to put that onto a big thing, because some legal descriptions are long. They're long, like they're a page and a half or something like that. But that's the description that you see. It's like some of them can be like meets and bounds. some can be like lot B, you know, I can't think of legal description right now. And so it's but it's the um but so some of them have like very long lengthy description, some of them can be very short. So it just kind of depends on what it is, right? So you're gonna put in the legal description there, right? Um, if you don't have a copy of your warranty deed, you're gonna have to contact the county of where the property is located and request a copy of the deed of the property, and then get a copy that way. Then you're gonna put the address of the property. That's the one that's gonna be like your property address, what you're used to, 123 A Street, Houston, Texas, right? So that's what you're gonna get on number 3. All right, and so now it gets wonky. Um, you're going to have 3 sections that you're going to pick from. It's either going to apply or it's not going to apply. All right. So there's going to be an A, B, or a C. You're going to pick either A, B, or C. All right. So A is both spouses own the property and you want to leave it to the surviving spouse. If you both don't own the property, if you're not married and you both don't own the property, you're not picking A. You're skipping over A. Okay, A doesn't apply. You're a single person, A doesn't apply. Skip it. No box is being crossed. No A is being checked in. Only if you're married and you want to leave it to your surviving spouse, you're going to check A. Okay? So you're married to each other and you're both signing this deed. Both of you are signing this deed. And if one of us survives and the other is living, the living spouse will be the sole owner of the property. That means that if, when I pass, my spouse is going to own this property. And then when we both die, so when my spouse dies, then it's going to pass to whoever's listed as the alternate beneficiaries. So this is creating the survivors. This is the surviving beneficiaries. Okay. Typically, I'm not saying this has to be you, but typically this is parents leaving property to children. This is typically what's happening here, right? I'm leaving it to my spouse and then we're leaving it to the children here. So that's typically what's happening in A. But you can do whatever you want, but that's typically what's happening in A. All right? And same thing with the pro se wills form. There's no instructions or anything like that. It's going to be equally divided. If there's 2 people, they each get 50%. Now, one of the things I will say this about the Todd, it is highly recommended that you do not have many people inheriting property. In fact, it is highly recommended that you do not have more than 2 people inheriting property. If you're going to have more than 2 people inheriting the property, you may want to consider thinking about doing it in a will with some instructions in a will about what to do there and talking to an attorney about what the impact of having more than 2 people own property. I think you should actually talk to an attorney about the impact of having more than 2 people inherit property and what that means down the line for that. And maybe there's some instructions that might be considered, some options about what that means for heirs when there's multiple people who own property. There can be some consequences to having more than 2 people owning a property and then having multiple people inheriting property. When you start getting into 4 people inheriting property and then there's a potential 1 person passes and they have 3 children and then we start potentially having 18 people inheriting property, there can be some detrimental consequences that you might not want, right? So if you're going to have more than 2 people at this level as your alternate beneficiaries inheriting property, I do highly recommend that you consider talking to an attorney about what the consequences may be and what the options are before you do more than 2 people has alternates in any way in a Todd. So that way you are fully informed about what the potential consequences are for it. Because there are consequences when you start having multiple people. And this is not to say, oh, it's like, well, I have 4 kids. What am I supposed to do? You just need to know what the what can potentially be the outcomes when 4 people inherit property. And when you do a Todd, and once it goes into effect, it can't be outdone. It cannot be outdone, right? Similar to a will. Sometimes when people are like, I'm just trying to do things as inexpensively as possible because I'm just trying to avoid probate. Sometimes you can create a problem at this stage because you're just trying to avoid an expense now, but you're going to create a bigger problem later that's going to be much more difficult to undo than by just having a better estate planning now. By talking about it now and then creating a better plan now. So that way later on we have a better solution. Because, it's okay. It's okay you had 4 kids. It's just maybe we need a different estate plan from a Todd. So, and doing something different. So that way we can plan for something so that way we're not making more difficulties for your 4 kids. So, so that's why I'm going to say usually it's 2 because there's reasons why, because it's better legally for there to be 2. Not to say you can't have more than 2, but there's reasons why. And and there's multiple reasons why. That's why we started getting into why it made it more complicated for me to give you a lot of like some of the reasons why property tax exemptions, qualifications for disaster relief, there are just 2 potential reasons. Devaluation of property. So there's just some examples of some reasons that you may want to consider different estate planning. Now we go to B. So A, married couple, survivor, likely children, beneficiary. B only applies if it only applies, right? Only one spouse owns the property. So you're married, but only one person owns the property. So it's separate property. You've already owned this house prior to your marriage, but you still want your spouse to inherit this property. So this is probably not as unique, but it is specific, right? And so you want your spouse to be the primary beneficiary, right? So one spouse owns the property, and now you want your spouse to be the primary beneficiary for the property. So you're going to name the spouse as a primary beneficiary. And then if the spouse passes away before you, then you're going to have the alternate beneficiary listed. And then there's going to be alternate beneficiary. This is really important to know. Really important to know if you are a single person who owns the house before and you pick this option. If the surviving spouse survives and they inherit this property, the surviving spouse owns the property. There's no survivor clause here. Period. So the surviving spouse owns the property outright. So when the surviving spouse passes away, the house will pass according to the surviving spouse's will, Todd, whatever they choose to do. Okay? So your alternates do not inherit when the surviving spouse dies under B. So if that's what we want, then we pick B. Alternates only come into play if surviving spouse dies before the alternate, before the testator. All right, so that is B. Otherwise, if A and B don't apply, It's C. Oh, I'm sorry. I'm all right. So for A and B, then you have a transfer on death. So both A and B. I'm sorry, got ahead of myself. So you see, there's a 1 and 2 where you name the primary beneficiary, alternate beneficiary. So both A and B will have a section 3 where you're going to name what happens with the alternate beneficiaries. What happens if the alternate beneficiaries should pass, right? So what happens if an alternate beneficiary should pass prior to their passing? So, right. So, and in which case you can either choose for that alternate beneficiary's interest to pass to their children or no one else, right? Um, so if you want that alternate beneficiary's interest to pass to their children, then you're going to pick A. So in my case with Bob and Susie, right? So we picked Bob and Susie. So we're always going to have Bob and Susie. And if Bob should pass away, then if you want Bob's 50% to go to his 3 children, then you're going to pick A, right? So Susie gets her 50% and Bob's 50% will go to his children, right? And then if you don't want that, then you don't want Bob's children to get it, then you're going to pick B. And then what will happen there, it will go to Susie, 100% will go to Susie. And if both Bob and Susie should pass, then the whole thing is canceled out and the property will pass according to the will.
Jesse, I got a quick question right here.
Yeah.
In this section, if I'm reading it correctly, this is only if Bob and Susie are siblings or your children, right?
Right. Yes. These are only if they're related.
Okay.
Okay. All right. Now we get to C. So if A doesn't apply, which again married, and you want your property to go to your spouse and then the children. B, you're married, but the property is only owned by one person. You want it to go to your spouse, and if the spouse passes, then the children or whoever it is. Then otherwise, everyone else or any other situation, you're picking C. So then everyone is picking C. Anyone else is picking C. A spouse is not the primary beneficiary. The spouse can still be a beneficiary, but generally, it's a spouse is not the beneficiary. So then you're going to pick C. So under C, you're going to pick your primary beneficiary. You can pick 2 people, 1 person, whoever your primary beneficiary is, and then 1 and 2. And then you're going to have your alternate beneficiaries. All right. So this is how it works, right? So primary beneficiaries is going to be who you're going to have. Alternate beneficiary. If all of the primary beneficiaries should pass, then it's going to go to the alternate beneficiaries. All right. So now we have the categories after that, the A, B, and C. You have to select an A or a B under each A, B, or C. So you have to pick a provision for under one. So right. So under C, you've listed your primary beneficiary and your alternate beneficiaries, and now you're going to decide kind of what happens when something happens to your primary beneficiaries versus your alternate beneficiaries. This is confusing. I understand this is confusing. All right. So what happens when you have 2 primary beneficiaries and one of them survives? So one of them hasn't survived and one of them has, right? So you have Bob and Susie. So Bob and Susie and one of them has passed. Bob has passed away. What do you want to happen there? Okay. If you want Bob's children to inherit, you're going to pick A. And then Bob's kids are going to get his share. If you don't want Bob's kids to get it, then you're going to pick B. That means Susie is going to get 100% of the property. That's what happens when at least one survives. So that's what A means. That's what the capital A means. Under capital A, if at least one of the primaries survives, you either want the surviving, you only want the named persons to get it, or you want their children to get it. Okay. So same thing. Now we're going to B. If no primary beneficiary survives me, what do you want to happen there? Do you want their children to get it? Or now do you want it to go to the alternate beneficiaries? So now we're talking about both Susie and Bob have died. Do you want Susie and Bob's children to get it? So Susie has 1 kid and Bob has 3 kids. They both died. Do you want Susie's kids to get it and Bob? So Susie's 1 kid will get 50% and Bob's 3 kids will get 50%. Then that will be A. You'll pick A under B. But you don't want that. Forget Susie's and Bob's kids. Now we're going to put them to our alternate beneficiary, which is Angelina. We picked one. We just named Angelina. Angelina is our only alternate beneficiary. If we don't want Bob and Susie's kids to get it, then we're going to pick B. So it goes to our alternate beneficiary, to Angelina. Okay. So that's what's going to happen under B. You're going to pick A, goes to their kids. So A is always going to be whatever named beneficiary it is going to their kids. That portion is going to go to their kids. Or B, it's not going to go to that person's kid. It's going to go to whoever the next person is, and whoever's the alternate is. Right. And then C, what happens if the alternate beneficiary doesn't survive? So now we're in the worst case scenario, right? So now when we get to C, the capital C under C, so Bob and Susie has not survived. We've said, nope, their kids aren't getting it. B, Angelina hasn't survived. So now what happens when Angelina doesn't survive? If you want Angelina's kids to get it, she's got 7 kids, right? Angelina's kids, I think she's got 7 kids. We want 7 kids, for Angelina has 7 kids. Then you want her, then you're going to pick A. Angelina's kids get 7. Nope, we don't want Angelina's kids to get it. Then we're going to pick B. No one else gets it. Now the Todd is voided out. It's going to pass according to the will. So that's what those sections basically mean. And you are going to pick one from each one, because what we're trying to do is to decide what happens under the Todd. We're trying to make sure that, are we trying to void out the Todd or not void out the Todd? Now here's the thing. We don't know what's happening, because when you do this Todd, Bob and Susie could still be single, right? So we don't know, right? We're just trying to plan for options that we may or may not know exist, right? For all you know, you're doing this right now when Bob and Susie are 18 and 22. And, but this Todd could be filed now, and this could be going into effect, in 40 years, because it's a family home. So, you may want to evaluate things and rewrite your Todds and things like that, and, manage your documents. Documents should never be one and done. You should always be evaluating them and looking at them to make sure that they still do what you want them to do when family dynamics change. But just kind of keep in mind that, has your family dynamics changed, that this Todd that you filed that may need to get revoked and updated or something like that, you may want to take a look at them and make sure it's still doing what you want it to be doing when family dynamics change. All right. I know it's very confusing. It does, just like the wills, it does say the instructions are there. Here's the good news. It's only really confusing when I'm explaining it. When you go through this if you can do this in the online interview system, when you say what you want, it will ask you what you want. Do you want it to go here or do you want it to go there? If you just remember how I explained it to you, right? It's basically going to be asking, do you want when it says that what happens with the primary beneficiary, do you want it to go to their children or do you want it to go to the survivor? Then that's, as long as you just remember that's what it's asking. What it's asking is, if there's two primary beneficiaries, do you want, if one of them should pass away, do you want it to go to their children or to the survivor? If the answer is their children, then you're going to pick A, the first option. If you want it to go to the survivor, then you're going to pick the second option. If they should both die and then it goes to the alternate, the same thing. Do you want it to go to their children or do you want it to go to the survivor? If not, if you wanted to go to their children, then you're going to pick A. If you wanted to go to the survivor, then you're going to pick B. So as long as you remember that's what it's saying, that it's either children or the survivor, children or the survivor. As long as you remember that, then that's what's being asked. Every single one of them, that's what it is. Children or survivor, children or survivor. All right. And so it's only confusing when I am explaining it, but when you're doing it on there, the way that's what it's asking. All right. And so, and then when you get through, it will go through and it will do all that. All right, so what to do next? With a notary present, you're going to sign the Todd with the co-owner, if applicable. Notary will sign and affix the seal, same thing. You're going to record the Todd. Todd must be filed with the county clerk in the county where the property is located. It's not valid until it is filed. Once recorded, the clerk will file the Todd, return the Todd to you, keep it in the same place along with all your other advanced planning documents. And with your will, if you change your mind, you must file a new Todd or revocation. Here's the good news. NRCDC does do Todd clinics, and I am sure Miss Nia is going to share all that information about Todd clinics that are the next ones that are going to be coming up and when those are available. So as confusing as I might have just made this, if you don't feel comfortable doing this on your own, there will be a clinic where people will be available to help do this for those of you who qualify. Will actually be able to draft them for you. And for those of you who don't qualify, I could be saying this wrong and Nia will correct me, but we'll help you actually walk you through the process of helping you do it, as well as finding the legal descriptions for your property and things like that. So there's help available for anyone who feels like this is so much. There's help available. Okay. All right. Next up, we do have additional forms that you can do. There's statutory forms of statutory durable power of attorney, medical power of attorney, advance directed to physicians, declaration for mental health treatment. And there's additional forms of declaration for guardian event of later incapacity, HIPAA release, and supported decision making. Again, I talk about each of these forms in part one and what they mean. But the good news is that those statutory forms, those four that I talked about, all of those are also available on that interview link that I shared and talked about. You can also do those on that interview form where you just go in and you say who you want to serve as your agent. And because they're statutory forms, the folks in Austin already wrote what they say and what they need to say. And all you really need to know is what the documents mean and what you want them to do. And it will be able to print them out for you. And almost all of those documents only require notaries. Those documents, actually, most notaries will do. But again, if once there are people available to do that, and so you can do those pretty easily on your own. But those you can find on the internet as well. But if you want to use that online interview system, it will print it out for you. Really simple, easy to do on your own. Okay. Again, I know this can be quite overwhelming, and I'm not trying to discourage you or dissuade you from being able to do this on your own. For some people, the reason why we do this presentation for those people to be able to draft them on their own is because there is a recognition that some people are not going to be eligible for services. But for those of you who are eligible for services and this is overwhelming, assistance is available. This is my organization. That's my contact information. Here it is on the screen. There are the other partners in the month of service, Houston Volunteer Lawyers and Earl Carl. We are here to assist you. The Texas Legal Services Center, they also have Texas Law Help. which is a website for self-help representation that can also answer a lot of these questions for you online. So there are resources available. So if you think you need legal assistance, not February, I don't even know what month we're in. August is actually National Right Draft a Will Month. So, but if you would like assistance, and you think you qualify for services, my organization will help write your estate planning documents for you if you qualify. So if you are interested in applying for services, this is us. You don't have to, again, partner organizations as well. And you know, but there, if you do want to write your own, hopefully this was helpful for you to be able to know what you do going forward. If you don't qualify for services and you want to hire an attorney, there is the Houston Lawyer Referral Service where they will give you the names of a couple of attorneys who do practice in estate planning. Obviously, these are attorneys who will pay to be able to help you do the document drafting, but they would be able to assist you in making sure that the documents are what you need them to be if you believe that these pro se documents do not do what you need them to do. All right. So, and so that with that, with 8 minutes for questions, um, I always like to end with a little cartoon. But here is our little deathbed, which is who cares about where he buried the gold? It's his passwords and other digital assets that we need, which is a good reminder that you also need to be sure that people have access to your digital accounts. So be sure you put together all that information and include that in your important documents as well, because I won't tell you how many times I've had to help a client break into an iPhone. So we don't break into the iPhone. We go and do it properly. But yeah.
Okay. Yep, we do have a few questions that are in. As Jesse was going, I was including some of the links that she was making reference to. There's the link to our YouTube channel to view the previous presentation, part one that she did. But all the links, all the documents, everything that she also made reference to will be included on the link that I sent out to you all, including a copy of this recording and then last month. So it'll be on the email as well as the link to the online interview that will, take you through the process of asking those questions and creating those documents for you. So I will say on the online interview form, make sure you actually download a copy of the forms, because I've seen people when they got to the end of that thing, they just closed the screen out and the document was gone, which means you have to completely start all over again. So make sure you download it once you're finished, so it gives you all the documents that you just created or that interview that you went through. Otherwise, you will have to start over. Uh, do, 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 do. Let's see here. Okay, recording of section one. I've already got that. Let's see. If a Todd is invoked and to the surviving spouse, do you have to file anything for the deed to be put in the surviving spouse's name?
I already answered that. They have to file the
That,
death certificate. Yeah.
okay. Can you file a death certificate online in Harris County?
Um, there's multiple ways to do filings. I don't know about regular phone. That sounds terrible. Um, I honestly, I I don't know how non-attorneys file
Is
in
that an
Harris
affidavit
County.
of
I don't
death
know
or
how
the
they do
actual death
recordings. I
certificate?
think there is a way to do a recording, um, but I don't know if you can do it online. I would have to check. I would have to check. I don't know. But Harris County actually has all the information on their website. You can just go to which is cclerk.texas. I don't know. You can just Google. You can Google the Harris County clerk, and they actually have a lot of their information really easily.
Okay, okay, she's talking about the affidavit of death. She said death certificate. I'm like, you can't file a death certificate at all online, but okay, it's the affidavit of death. Yeah, I'm not sure that you can. Uh, yeah,
I
you'd
mean,
have to
Harris County's
call.
website is actually really pretty. thorough on their information on how to do everything.
Yeah, contact the Harris County Register of Deeds. Let's see. What if property is owned by siblings inherited from parent? And this section came up, this question came up during the Todd as being, I believe that's when she was asking that question. What if a property is owned by siblings that is inherited from parents?
Like,
Ms.
can you do a Todd if you own property with your siblings? Is that what the question, like, is that what you mean by
Uh,
the question?
Ms. Berger, if you're still there, if you want to unmute yourself and kind of give more reference.
Yes, that's what it's like if there's like three siblings that inherited property from their mother who passed away.
Mhm.
I know that was saying always about a spouse,
Mm.
but I'm talking
So
about like siblings open them. Can you do a TOD?
yes, I would probably say though, y'all probably should start having conversations about what to do because you're already at four people owning the property. You're going to start getting into very complicated property ownership. You're already at a complicated property ownership thing, situate. I mean, being honest. So y'all might want to have conversation. You might want to consider having a conversation, but you can only do a Todd for the portion that you own. So, presumably, without knowing anything, you each own a 25% interest in the property, so you can only pass the 25% interest that you own. And so you can do a Todd for your 25% interest, but just know then that like your 25% interest is going to get further subdivided, their 25% interest will get further subdivided. So the family may want to start having a conversation about how to stop the devaluation of the property as it gets further divided. It's going to start harming the property value. And so and then it's going to start and it will create other problems beyond property value um down the line. But yes, you can always do a Todd for whatever you own. Just like the two spouses, the 50% that they own, they're doing you but if you do a Todd for but if you're going to do a Todd to answer the question you're asking, to do a Todd, you just pick C. The option you will be doing, you just pass A, B, you just go straight to C because you're not a spouse.
Thank you.
Mhm.
Can you explain what a ladybird is if the Todd affects the ladybird deed?
So you're basically going to do one or the other. You're not going to do either. Because if you do a lady bird deed, you've already transferred your property. So a lady bird, so they're both you're transferring your property in both cases. So a lady bird deed is a lifetime is a transfer is what is known as an enhanced life estate. So you've transferred the property to another person, retaining a life estate for yourself. So you've already gifted the property away. So now a new person already owns the home, except now you've retained an enhanced life estate. So that's what a ladybird is. And then a Todd is that you still own the home, except that you have now done a transfer on death deed. And so now the property will get transferred when the ownership transfer will take effect upon death. Usually, when people are asking me about the difference between a ladybird deed versus a Todd, they're usually thinking about the effect, and what they're thinking about is what they're going to do about Medicaid and the Medicaid estate recovery. They both have the same effect of protecting the home from MERP, from the Medicaid estate recovery program. So they both will protect the home. The difference is whether or not we are now trying to think about becoming eligible for Medicaid. And usually a ladybird is what's needed to become eligible for Medicaid. That's usually what we're thinking about when we're thinking about using a ladybird versus doing a Todd. This is something you need to talk to an attorney about, to talk about your specific situation, to know what is the best thing to do. There are some very, very serious unintended consequences that can happen with a ladybird that cannot be undone, that can be undone when you do a Todd. So you do need to talk to an attorney if you think you need to do a ladybird.
Mhm. There was another question here. I have a business. Can I put that in a will or a Todd?
A business? Business
Hmm.
needs to go in the will. Todd's only apply to land and real estate.
Hmm.
Now, the business is land and business is like on real estate. You can do that in a Todd, but I would probably highly recommend that you still talk to an attorney about what to do with your business because those are separate things, right? If your business is a building and land, then all the Todd's doing is dealing with the building and the land. It's not dealing with the business, right? The business itself is its own is an entity that's not related to property. So the business itself needs to go into the will. You can deal with the property, the building and the land in a Todd, but I would probably recommend that you do that all together in a will. I don't typically deal with business owners in my work, but yes, you I would probably do all of it in a will. But there is definitely things you should consider as a business owner. There's no reason why you couldn't do it in a Todd, but
I I think from my recollection from the last attorney from you guys' office that did it last time, it depends on the ownership of the land or the building. If
yeah.
it's in the business name, then you can't put that on a Todd. I thought she said that you couldn't because
Oh
it's
yeah,
all
yeah. Like I kind
it's
of
gonna
assumed he was talking about it from the perspective of being like a solo, like he owns the business,
oh
like he or
as a
she,
sole
they, person.
proprietor.
Yeah, yeah, no. Like if the corp owns the business, then the corp can't do it then Todd. Yeah, I don't think so. Yeah.
Okay, so maybe we should plan another business owner estate planning session again for
Yeah,
later
we
in the
probably
fall.
do.
Yeah,
Yeah.
we've done one of those before, so let us look into scheduling that for the fall if that's something that more people are actually interested in because we did do that one last year too.
We did.
Um, let's see. Okay, she has a homeowner's firm. Let's see, can I do my own? Okay, I don't. We don't want to get into conversations about trust because she asked about trust. Todd's for cars.
Oh, so there is a transfer on death option for a car. It's called the designation of a motor vehicle beneficiary. So I didn't talk about that. It's a super simple form that you do it with the tax assessor collector's office, actually, believe it or not, because that's where we do car titles. So it's called a designation of motor vehicle beneficiary form. You can, I think, I think you send those
Yes.
too. I don't usually recommend those because it's expensive. In Harris County, it's like $70 or something like that. You can do it for your car if you think it's going to be your last vehicle, but you can do it. It's like a one pager. You file it, and then it's an application for a new title, and then you'll get it back. And it will be a title that would be a designation of beneficiary, and it is just like a title, and then you don't have to actually file anything when the person passes away. The death certificate with the new title will be sufficient when you want to go sell the car. Um, but that's the form that you would complete. It is actually the exact same form as filing for a new title.
Okay.
And there also is, you can also now do a transfer on death deed for mobile homes, for manufactured homes. And you would just designate it with your um, with your manufactured home documentation. So when you would do a right of survivorship, you would actually just do it in the form is the same form. So before you could create a right of survivorship, you would now just do the same documentation in you could just do it in the same you could always do a Todd when you declare the manufactured home has real property. You are always able to do it. For those people who have now declared a manufactured home has real property, you are now able to do the same right of survivorship um uh, declaration, do a Todd has real property. So you would just go back and refile your ownership documentation, doing a um, survivor transfer on ownership on survivorship.
Okay. There was a question about someone either setting up like a Todd or a will, where the children each wanted to do something different with the property. So we're actually going to go over that in the next session in the clearing title for inherited property. So when you're, what happens after you pass and you've got children that both want to do something different, what happens there? So we're going to talk about that. That's another whole long,
Good luck.
another long presentation that we're going to go over that in that session. So please join us for that next Thursday at 1 p.m. This is probably, I believe those are all the questions that were emailed to us. Yep, that's all I got there. Um, I believe that's all also that was in the chat. If I missed anything, please unmute yourself as we're kind of wrapping up here and ask your question. If I skipped over anything, I do apologize if I did. Let me check um, on the YouTube page as well, just to be sure. But yep, there wasn't anything else there. Okay, nope, there was nothing there as well. All right. With that being said, again, next Thursday is, I guess we can kind of technically call that part three of the whole thing. Part one is, preparing before someone passes. This is part two if you want to do documents on your own after, before someone passes. Part three, I guess, in essence, will be what happens after someone passes away, what the whole probate process is like, address any of those kind of concerns when there's multiple heirs, when there's a will, when there's not a will, exemptions and things that are available. And then if there were deferred property taxes on the property, what the payment options and things like that are available for inherited property that you get. So we're going to go over all of that next Thursday. Later on in the month, we have our maintaining and adding value to your home. If you have a home and you want some home maintenance tips and what actually adds value as far as renovations and remodeling, we've got one of our licensed Texas Trek inspectors. They're going to be on the presentation, as well as a licensed appraiser that's going to be on that gives you guys very, very good tips about home maintenance and adding market value to your home. For there are any renters, we have evictions presentation that's coming up on the 18th, but I'll include our schedule of all of our August workshops that we've got that are coming up in the email that I sent out as well. But you can always visit our website and go to our events page where you went to register for this, and all of the workshops will be listed there as well for you to register for. There are couple of will clinics that we have that are coming up that you have to register prior to in advance for because none of the will clinics are kind of walk-in kind of clinics, or everybody just kind of shows up. So it doesn't work like that, but I'll include that information in the email for you. We have our property taxes, exemptions, and other payment options on the last Wednesday of the month on the 26th, and our HOA foreclosure is part of our three-part foreclosure prevention series that's always the fourth Thursday of every month. That's going to be on Thursday, the 27th. That's coming up. Ms. Jessie also did mention that if there are notary that NRCDC, our neighborhood recovery, also offers notary services. If you've got documents that need to be notarized, then we do have that service here available to you all at no charge. If you'd like to set up an appointment to come into the office to get documents notarized, then please let us know. I'll include that in the email that goes out to you all as well. Again, the link for the previous presentation that Jessie did, part one, wills and advanced legal planning and why do you need it, where she goes in detail of all of those documents. That link presentation, along with the templates of all of these documents, you guys are going to get everything. So don't worry, it is going to be a whole lot. So please feel free. Every other month we do these presentations, so please feel free to come back, watch those recordings as often as you like. Please, if you feel it'd be beneficial, to share it with somebody, your coworkers, your other family members, when you guys are getting together for Sunday dinner, or having a family reunion or something. Have the conversations with your family and to try to help avoid a lot of the issues that come up when people don't want to have the conversations about somebody passing away or becoming incapacitated, to avoid a lot of turmoil and conflict down the line. It is very essential. People are losing their generational wealth every single day. You get a lot of investors, little crooked deals and things that are going on. People don't want to pay taxes, and you got tax foreclosures that come up. There's a lot of complicated things that can happen when you don't put things in place. Not to mention the amount of stress um, and mental anxiety and angst that you put on somebody that does not handle their situations prior to someone passing. It one of the best gifts that you can give to your family is to take care of this kind of thing, because there's nothing to like having to grieve and try to handle people's affairs and business things at the same time when you're trying to figure out, how am I going to get the mortgage paid because I don't have access to bank accounts or funds or things like that? Who's going to take care of my kids? What's going to happen to the grandkids and the dog? What happens, to that kind of thing. So please, do whatever it is that you need to do to make sure that your things are handled. But I will say this: please contact reputable sources. Please stop listening to the street committee and thinking that the world of social media on TikTok and all this other kinds of stuff, where people put these blanket statements out there about uh, probate issues and laws that are not even relative to the state of Texas. So please be careful as to where you guys get your information, and do your research on your own and ask questions, please. So with that being said, thank y'all very much for joining us this afternoon. We really do appreciate you coming by and joining us today. We hope that you all found the information to be beneficial. Again, we invite you to come back and bring your family members if they want to sit around the computer and watch and have a conversation. Hey, make it an afternoon thing. You're going over to talk with your grandmother, take her a couple of sandwiches, some hot tea, and y'all sit in front of the computer and watch the presentation and have her ask questions. So thank y'all very much. Again, there's going to be a brief little survey that pops up on the screen. If you guys could take just a moment, please let us know how we did today, if you found the information beneficial, and if there are any other things that you all would like to have us offer. If there are workshops or services or information that you need where we don't currently offer, please reach out to us. Everybody in our collaboration is a wealth of information and resources that we can point you in the right direction. Maybe we may not know the answer or personally do the service ourselves, but we'll do our best to make sure that we get some information to you that you all need. So, and do not automatically discount yourself and assume that you won't qualify for services. Please apply for free legal assistance with Lone Star Legal Aid and our other legal service partners that are part of the A Month of Service collaboration. So you all have a wonderful remainder of your day. It's getting a little bit cloudy out there, so stay dry, and you all take care of yourselves. You stay safe, and we will see y'all again soon. Thank you, Jesse. Thank you, Miss Pam, Miss D.